Thank you, ladies and gentlemen. I'm very grateful that I'm here with you this afternoon. As you can see, I deliberately stayed through all sessions, but because what you had to say, I believe, is very important for me and for my mandate as both deputy prosecutor, but also as prosecutor-elect of the International Criminal Court starting in June of 2012. I will be reflecting on the similarities between the R2P and the International Criminal Court. And as you know, there are quite a number of similarities between the two. And for me, one of the most important is that both of them, that is the court and the R2P, are born from experiences of states when for decades states have failed to address and to prevent massive crimes. And states have learned from reality. We have seen that never again has been an unfulfilled promise. We have seen that 30 years after the Holocaust, the international community had failed to effectively to prevent or to stop or to have an effective policy to stop the Khmer Rouge. And 20 years later after that, it could not also prevent the cold blood execution of Srebrenica. We also neglected the machete and the rape-driven genocide of Rwanda, as well as the death of millions in the Congos. The Rome Statute system, just like the R2P, was also an innovative response that the world was looking for centuries to establish order. Unlike the R2P, it is respectful of the plurality of sovereign states, but at the same time, it ensures the punishment and prevention of crimes through an independent court of last resort. The Rome Statute system offers a solution as a new instrument of peace, which is creating global governance without a global government, but with international law and courts. Accountability and the rule of law provides the framework to protect individuals and nations from massive atrocities and to manage conflicts. And citizens of the states parties to the Rome Statute are under the protection of the International Criminal Court. And by seeking to end impunity, the court has added an essential tool for implementing the responsibility to protect. The court and justice in general are part of the responsibility to protect. United Nations Security Council Resolution 1970, unanimously calling upon Libya the responsibility to protect by referring the situation to the International Criminal Court, has shown that this can actually work in practice. And the primary responsibility for the investigation and prosecution of the gravest crimes lies within the national jurisdictions as the first line of defense against impunity. And in this light, it is worth noting that the United Nations Secretary General Ban Ki-moon, in his 2009 report on implementing the responsibility to protect, acknowledges that states should become parties to the Rome Statute as the first step towards the full implementation of the responsibility to protect in practice. The Rome Statute's core international standards need to be faithfully embodied in national legislation so that the specified prospect of crimes and violations and their incitement are criminalized under domestic law and practice. And in this regard, As noted again by the Secretary General, particular attention should be paid to preventing sexual and gender-based violence. Coming to the second pillar of the responsibility to protect, the international community is directed towards encouraging and assisting national states to protect their populations. To proactively encourage and assist national proceedings and help prevent future crimes, the Office of the Prosecutor of the International Criminal Court has adopted a policy of positive complementarity as part of our prosecutorial strategy. And during our preliminary examinations, throughout which the Office monitors situations to assess whether or not we should open investigations, we make public announcements of the beginning of the investigations, examinations activity. The messages also that are delivered by the international community directly to key decision makers can help dissuade them from destructive courses of action that could make them subject to prosecution by the court. And the office is also, the Office of the Prosecutor, is also in the same vein able to send missions and request information from governments. And this information that we request for can be factored in by states and relevant organizations in order to promote timely accountability efforts at the national level. Example in Guinea, we sought to encourage and cooperate with national and international efforts to conduct genuine national proceedings. In Colombia, the prospect of the court exercising jurisdiction was also mentioned by prosecutors, by courts, by legislators, and by members of the executive branch as a reason to make policy choices in implementing the justice and peace law. Now, under the third pillar of the responsibility to protect, when a state is manifestly failing to protect its populations, the responsibility to respond shifts to the international community. Similarly, under the Rome Statute, the court will step in when a state proves unable or unwilling to genuinely investigate and prosecute massive crimes. While the actual or apprehended commission of massive crimes can be said to trigger an international responsibility to intervene in order to prevent further crimes or suffering, the International Criminal Court holds out to violators the tangible threat of punishment. And pursuant to our policy of focused investigations and prosecutions, the office will investigate and prosecute those who bear the greatest responsibility for the most serious crimes. And accordingly, the office will continue to support a comprehensive approach to combat impunity and the prevention of recurring violence by combining our own efforts while encouraging and supporting national investigations and prosecutions of other alleged perpetrators, as well as truth and reconciliation mechanisms. The court's coordinated activities in the situations of Uganda and the Democratic Republic of Congo, just as examples, provide good examples for these coordinated efforts I'm referring to. But however we see in the situation of Darfur, the power of the court to prosecute violators will remain ineffective if accused persons are not arrested and surrendered. Therefore, there must be a corollary responsibility assumed by the international community should a state fail to enforce judicial decisions related to underlying protective norm. And as stressed by, again, I cite Ban Ki-moon, there is a need both for the cross-sectoral approach and for sharing the burden in a common effort to eliminate, once and for all, the massive crimes that plague our countries. I mentioned in my election acceptance speech during the Assembly of States Parties in December that the Office of the Prosecutor is a key component of the Rome Statute system. It is the trigger of the court and the driving force behind the cases brought forward for prosecution. Yet the Office of the Prosecutor is not and cannot be an isolated organ divorced from other components of the international system. On the contrary, the court will do only a few cases, but each case can have an exponential impact to reach beyond the confines of the courtroom. As Moreno Ocampo, prosecutor of the ICC, and also Ban Ki-moon, I like citing Ban Ki-moon, as you can see, there is now a large shadow of the court, they say, referring to the impact of the court or a single court ruling extending to 121 states and even beyond to reach non-state parties. The Rome Statute and the activities of the court are affecting the behavior of governments and political leaders. People involved in development programs are making the connection, and armies around the world are adjusting their operational standards, and conflict managers and peace negotiators are refining their strategy, taking into account the work of the court, respecting the legal limits. I think increasingly the world is understanding the role of the International Criminal Court. Our prosecutions in Kenya could support the process of structural reforms in that country and can help to prevent violence from happening again in the next presidential elections this year. Another example is our trial case against Jean-Pierre Bemba, who is charged for allegedly commanding crimes, including mass crimes committed in the Central African Republic. And that case goes to show that gender crimes will be prosecuted and that commanders have a responsibility to ensure that warfare is contained within the limits of the law. I believe this is the way forward. Step by step, the Rome Statute system is moving ahead and creating a new international dynamic, impacting other institutions and changing international relations forever. As the next prosecutor of the ICC, I hope to contribute to solidify this change, remaining committed to the goals of the court and the legal mandate entrusted to the prosecutor to end impunity for those responsible for the gravest offenses, bringing justice to their victims and preventing future crimes. Thank you for the invite.
Thank you so much for this speech. I'm Mark Leon Goldberg. How would you describe how your forthcoming tenure might differ from your predecessor? Do you have individual priorities that might be a little different? I'm just really trying to get your take on what might we expect that's different from what we've seen in the past few years.
I think one thing that I have had the advantage of is that I've been at the court for the past 7 years, going on to 8 years at least. And the advantage that that has given me is that we have tried and tested various things. I have had the benefit of seeing what has worked very well, what needs to be improved, and perhaps what shouldn't be done again at all.
Is there anything sort of specific in that?
I'm coming. I'm getting to that. I'll give you the background first. Let's take the example of our policies in disclosure. You know, just to give an example, if you would remember, during the Lubanga case, we have had our problems resulting in the Lubanga case being stopped twice. And coming back to having the advantage of staying there, of being there the past 7 years, is that I was, together with other members of the office, we were able to work on our strategies and ensure that this wouldn't happen again in any other case. You know, that is just one concrete example I can give you. And with respect to, if you look at Katanga, if you look at Bemba, if you look at the Darfur cases and all of these other cases that come after Lubanga, this problem has been averted. I have been part of that process, and I hope that, I'm sure that even in the cases that come after the current ones, this cannot happen. That is a concrete example I can give you. Another area that, of course, I intend to focus immediately on is getting a good deputy. A good deputy prosecutor. As you know, that is a process that I have to submit 3 names to the Assembly of States Parties for elections. And I hope to be able to do that. It's one of my priority areas. And you have another question?
Hello. Just a question, since you've been there for a while, there's been a lot of criticism from Africa that the cases are too focused on Africa. I understand that most of those cases are cases that have been referred by the government, and except the ones referred by the Security Council. But notwithstanding that, do you see that as a problem, and do you see that as something that needs fixing? I mean, do you expect to be looking more carefully sort of in other parts of the world?
Look, I do not think that that should be taken as a criteria, that because we are in Africa, and I'm glad you mentioned that, the cases, how the cases came to the court. I don't think this was any deliberate effort on the part of the ICC to go after African cases, but 3 African countries happened to refer cases to the ICC, and twice the UN Security Council decided to refer cases also to the ICC. And I think it was only in one occasion that the prosecutor used his proprietary motor powers to start a case. This is in Kenya. And even after all those criticisms that you have heard against the ICC, Cote d'Ivoire has come to request the ICC to come in. I do not think that geographical considerations should be the criteria for ICC taking cases. I mean, we were set up to go after those who bear greatest responsibility for committing these crimes, wherever it may be, wherever it may occur. I am not going to guarantee you that if tomorrow another serious case is happening in Africa that warrants the intervention of ICC, we wouldn't intervene because we say that we have too many cases in Africa. I think then we begin to lose our credibility, because this is not a criteria for me.
Michael first, and then we'll go to Heather.
That was an extremely insightful and helpful presentation, and I thank you for it. I'm wondering whether you can talk a little bit about the connection between the Libyan air operation, the military operation, and the indictment process. There were those who criticized the ICC as being too politically geared in to the military operation. The indictments, as I understand them, depend to some extent on NATO intelligence sources. There are those who would argue that while you presented a very good case that the ICC and the R2P process to be together, Libya might be an example where it's a little too close for comfort. I'm just wondering whether you had any thoughts about that, and whether there are, and the subsidiary question is also the political question of whether indictment of sitting heads of state responsible for crimes against humanity whether the indictment process makes the short circuits the possibility of a political solution, a negotiated rather than a judicial end to into a process. It's the give the rat a hole to hide argument, and I'm just wondering whether you can address that issue.
Just to take your second question first, I've always said that it is not the ICC's indictments that are obstructing peace. I don't think so. I think it is actually lack of enforcement of those indictments that obstruct peace and justice. I think the international community should speak purposefully and with one voice. If the ICC has gone out to investigate and issue indictments against someone, whether a sitting head of state or not, I think the ICC should be helped to get those bodies before the ICC and speak very consistently and purposefully and with one voice and do that. But this positioning of peace versus justice, let's sequence, let's have peace first, then justice later, or maybe not arrest now and arrest later. This is sending conflicting messages that is not really helpful for the court. Of course, I am sensitive. I know sometimes the political atmosphere does not help. We all have seen what is happening in Darfur with Bashir and the warrants that we have issued first against Harun and then against Bashir. I think that if at the time and with that momentum, the world has really, the international community has reacted to really help to isolate, and we had the discussion this morning about Bashir having friends. But if there was a determination to isolate and get Bashir, arrested and surrendered to the ICC, I think it would change the dynamics of what is happening in the Sudan today. And it's unfortunate, and I asked this question this morning, I think that the international community could have done a lot better with the situation in Darfur, definitely. Your first question was about with respect to the Libya situation. I think this was a situation that we felt that there was consensus. With the 1970 resolution, there was consensus. There was a momentum that has arisen that I do not think that the ICC should have just waited without acting. It was necessary for us to act in the way we did and to get the indictments out in that speed of time, because you lose time. That is something that we need to also reflect on. You lose time, circumstances change, political considerations, things change. And then maybe the opportunities that you had then, when you had consensus of moving your case forward and getting the indictment out there, you will lose it like that. And you would see that, of course, we have used open sources, in our investigations, but we were also able to do our own investigations. We acted very fast. We probably did not immediately go to Libya because of the security situation, but you will recall that at that time, there were already people leaving Libya, very high officials leaving Libya, defectors who we could immediately engage and get the information that we need to present before the judges. So these were two interventions that I think were moving in parallel. And maybe that is why you would say that it was too close for comfort. But I think both of them had to move in the way they did, including the ICC and our intervention.
Great. I think we're getting close to our time, so I'll take a cluster at once, I think. Barbara, do you want to go? And I'll also take...
Quickly, because I was going to start Libya also. Whether now you're faced with an additional task for the court to help if the Libyans wish to keep the people that have been invited, particularly outside Palestine, in in Libya in trying to also bring up to speed their justice system, and what kind of complexities do you see ahead in dealing with these cases if the Libyans want to try them?
Well, already these are the indications that we have, that they want to try them. You will note that as soon as we heard that Saif Gaddafi was arrested, I think we were the first people, but I mean the prosecutor and myself, we went to Libya, and this was just to get first, to encourage them then to have the ICC case going, but they were very clear from the very beginning that this is a case that they would want to do. They want to prove something to the world, that as opposed to what happened with Gaddafi, they want to show a different side of Libya in the case of Saif. The court system, the ICC is complementary. You know, there is complementarity. If a state says that I'm going to do it, the ICC will have to wait. I mean, this is what the statute says, and I think this is this should be clear. We will continue to do what is required of us under the statute, and that is we will try to work with them. We'll try to monitor what they are doing. First of all, they are bringing their challenge. We are waiting to receive that. As you know, just last week, they requested for an extension, which was granted to them. But that is an admissibility challenge, which is, again, under the Rome Statute. And we have to say why we think that we don't think they can do it, or we agree that they can do it. But it is a challenge that has to go before the courts, and all of the parties involved will make submissions. And then we will see what happens. But definitely this responsibility that they will investigate and they will prosecute, we have to let them do that. If you know, unless somewhere down the line we find that it is not genuine prosecutions. But I don't think that will happen in the case of Saif.
All right, I think we'll take two last hands that I saw, maybe together, and you can answer them together. Mr. the first, Mr. Evans, and then that.
I'll do a little bit more on peace versus justice. Are you irritated or grateful at the existence of Article 16 of the Rome Statute, which does vest in the Security Council the capacity to halt indictment, effectively maybe in perpetuity, if they take it that the interests of peace and security will be served thereby? You've heard me in The Hague, I think, some time ago, arguing that really we put a bit too much responsibility on the prosecution's shoulders to exercise discretion in these respects, and that really we ought to let you get on with bulldog intensity dealing with the issues of impunity and prosecuting those who want to be prosecuted, but recognising that particularly in the case of ongoing conflicts as distinct from concluded conflicts, you just might on occasion get the need to let the rat pick in a hole, as Michael, the usual elegance puts it. So, you know, you do have that mechanism available there, so the short point is, are you pleased about that, or just irritated with the second guessing that potentially involves?
No, actually, I think at the time that the Rome Statute was negotiated, I mean, all of these situations, possibilities were in mind, that there could probably be a situation where it would be more expedient to use Article 16 than to go through with investigations and prosecutions. My only thing with it is that if it is to be used, it has to be used in the proper way that it was envisaged. You know, that there is definitely good chance that this conflict can be resolved by using Article 16. It should not be used as a political tool. This is my...
The term of the first prosecutor has very much been about establishing the court and getting a number of cases going. Now we have lots of cases and a more or less flatline budget. So perhaps your term is going to have to involve the closing of cases and perhaps all situations. And I'm wondering how you are thinking about when is the right time for the ICC to exit. What will those criteria be? When is there sort of quote-unquote enough justice in a given situation?
You know, if you note with the ad hoc tribunals now, they're all thinking about their completion strategies and how how to exit. And the way I look at it, is that, even though ICC is a permanent court, we should have exit strategies, in the sense that we cannot, let's say, stay in the DRC forever. Neither can we have the LRA on our case docket forever. There should come a time when really we think of leaving the situation, and you're rightly asking for what strategies are we putting in place. I wouldn't say that we have completely, put together a package. But definitely, with respect to, I can give you the example of Uganda, on case-by-case basis, we're thinking about that, and we're doing that. Uganda is thinking of, as you know, have already put in place, a situation in which they would be doing cases by themselves. They're taking over cases to do it by themselves. Of course, it is not the ones that are the targets of the ICC, but others. But what we have done is we are working with Uganda. In fact, they have already fielded some visits to the court, in which we're helping them, exchanging information, but also helping them with their policies, their strategies on how to conduct these international investigations and prosecutions regarding others. So this is a way which we feel that we can work with the national system and to assist them to be able to take cases by themselves, so that the intervention of the ICC will either be ended or be quite limited in respect to, and faded out gradually. Again, if you look at what we are doing with the Kivus in the DRC, we're trying to see how we can work with the national systems so that we can cover more cases in the Kivus than we did maybe in Ituri. We will work with the local judges. The situation of protection of witnesses, as well as of the judges themselves in this case, or magistrates, is huge. So it's not just a challenge that one can take lightly. It's something that has to be considered very, very closely to see what is the best way we can maximize, both ours and the intervention of the local judiciary in the Kivus. So these are some practical ways we are thinking of, because obviously if we decide to intervene also, we shouldn't, to leave the situation, exit the situation, we shouldn't leave it where cases are hanging. We have to look for a good way of exiting, while at the same time the local judiciary can, for example, continue in some form investigating and prosecuting.
Thank you very much. I think time is telling me that we have to wrap up, unfortunately, but thank you very much to Ms. Bensouda for sharing these comments with us.
Thank you.